Today let's talk about um, Armed Forces Decision Regional Bank Lucknow Original Application of 475 2023। तो आज हम लोग एक नया केस लेके आए हैं आर्म फोर्सेस ट्रिब्यूनल का, इंडियन आर्मी का, जिसमें जो है एक हवलदार हैं सुनील कुमार सिंह। उनका केस है डिसेबिलिटी पेंशन से रिलेटेड। तो उन्होंने आर्म फोर्सेस ट्रिब्यूनल में केस किया था। उनका केस केस का जो है ब्रीफली स्टेट क्या है वो आपको बताते हैं। The applicant was enrolled in the Army Medical Corps of Indian Army on 18/12/1996 and was discharged from service 31/12/2022 and in low medical category on completion of term of engagement under Rule 13(3) and Section Item 3 first of the Army Rules. 94 after rendering 26 years and 14 days of service. The applicant is in receipt of service pension during service. While posted in 326 Field Ambulance, the applicant was granted 50 days balance of annual leave for the year 2004 with effect from 16/5/2004 to 4/7/2004. The leave address of the applicant was his native village. For reporting to his unit, the applicant had train reservation up to Jammu Tawi in the Himgiri Express, with scheduled departure on 3/7/2004 at 7:35 p.m. from Lucknow. To rejoinder duty, the applicant left his native village on 3/7/2004 is about 3 p.m. by scooter along with his brother to board a train at Lalganj for Lucknow on onward scheduled journey to Jammu Tawi, but before reaching the railway station, he met with a severe road accident and he sustained severe injury with his brother died on the spot. Being severe injury, court of inquiry was conducted wherein commanding officer 326 ambulance on 12/4/2005 made remark that I concur with the opinion of the court number 2. Tripahi Assistant Yaskes sustained injury in the process of rejoining his duty on annual leave under circumstances where beyond his control. The disability is not attributable to military service. At the point of discharge from service, Release Medical Board held at 155 Base Hospital on 12/7/2022 assessed his disability open communicated fracture femur shaft RT right opted as 70 to 30% for life and opinion the disability to be neither attributable to nor aggravated by service. The applicant claim of grant of disability pension was rejected while dated 30/12/22. It is in that perspective that the applicant has preferred the original application. OA. अब ये रहा कि उसकी डिसेबिलिटी के बारे में उसने बताया, ठीक है। अब नंबर सेकंड पे देखते हैं। Learned counsel of the applicant also submitted that a billion 50 days balance annual leave for the year 2004 from itna to rejoinder duty. The applicant while returning his native village scooted with his brother to board a train at Lalganj for Lucknow for onward scheduled journey to Jammu Tawi, met with a severe road accident and he sustained severe injury, which ultimately resulted into 30% of disability for life. Because of open comminuted fracture femur shaft (OPTD), inside of that, Court of Inquiry as well as RMB has been denied the attributability on the ground that injuries sustained while on leave. He submitted that Honorable Apex Court, various Honorable High Court and the benches of AFT in the matter of disability has held that If an armed forces person suffered from disability during the course of service, which was never reported earlier when she or he was enrolled recruited in the army, the said disability would be treated to be attributable to or aggravated by military service, and he shall be entitled to the disability pension for the same. Further, late counsel of the applicant especially relied upon the law laid down by the Honorable Appeals Court in the case of Union of India and others versus Surinder Pandey. Thus, he submitted that applicant case being fully covered with above, as he also suffered injury while returning from home to rejoin his unit after availing balance annual leave. He is entitled to disability element of disability pension and its rounding off to 50%. Per contrary, learned counsel of the respondent considered that applicant was granted 50 days annual leave from इतना इतना in 2004. While returning from home, Palia Beat Singh put to board the train to Lalganj for Lucknow and onward to Jammu. He met with a road accident and sustained the injury. The applicant was subsequently diagnosed as a case of open communal fracture femur shaft. He further contended that disability of the applicant 30% for life and has been regarded as NANA by the RMB of the basis of injury report dated 3/4/2005 and the court of inquiry dated 12/4/2005. Hence, applicant is not entitled to disability element of disability pension in the term of regulation 53A of the Pension Regulation of the Army 2008, which provide that an individual released, retired, discharged on completion of term of engagement or on completion of service limit or on attaining the prescribed age period of engagement, if found suffering from a disability attributable to or aggravated by the military service and so recorded by release medical board, may be granted disability element in addition to service pension or service gratuity from the date of retirement discharge. If the accepted degree of disability is excessed at 20% or more, he pleaded for dismissal of the OA. We have heard Sri Yashpal Singh, lead counsel of the applicant, and Sri Amit Jaiswal, lead counsel of the respondent, and also persuade the record. After having heard the submission of learned counsel of both sides, we found that there are certain facts admitted to both the parties. The applicant was enrolled in the army in Hitta. He sustained an injury before and met with severe road disease 30%, but the disability claim of the applicant was rejected 30/12/2022. The respondent have denied disability element of the disability pension to the applicant on the reason that getting disability pension in respect of the injury sustained during the course of employment, he must be some causal connection between the disability and military service. And this being lacking in applicant case as there was no causal connection between the disability and military service, he is not entitled for the same. The question has been considered time and again not only by the various benches of AFT but by the Honorable High Court and the Honorable Apex Court. In more than less similar cases, decided on 20 September 2019, the fact of the case were that respondent of that case met with an accident during the leave period while riding a scooter and suffered head injury. A court of inquiry was conducted in that matter to investigate into the circumstances under which the respondent sustained injury. The brigade command have gave record the that injury occurred in peace area were attributable to military service. One of the findings of the report recorded under column 3 was that no one was to be blamed for the accident. In fact, respondent lost control of his own scooter In this case, the respondent was discharged from service after rendering pensionable service of 17 years. In pursuance to report to the medical board noted his disability is 30%, the claim of disability pension was rejected by the medical board on the ground that the disability is neither attributable to nor aggravated by military service. An appeal filed by the respondent against the rejection of his claim for the disability pension was rejected by the Additional Directorate General Personal Service. Respondent then filed an OA in Armed Forces Tribunal against the order of the denial of disability pension, which, after relying upon the judgment of Honorable Apex Court in the case of Madan Singh Shekhawat versus Union of India, SSC 459, was allowed by the tribunal, holding that respondent was entitled to disability pension. Aggrieved by the same, the civil was filed, in which the Honorable Apex Court framed following 3 points of consideration: whether an armed forces personnel proceed on casual leave or annual leave or leave of any kind, he is to be treated on duty; whether the injury or death caused, if any, the armed forces personnel is on duty, has to have some casual connection with military service so as to hold that such injury or death is either attributable to aggravated by the military service. What is the effect and purpose of the court of inquiry into an injury suffered by armed forces personnel? The Honorable Apex Court decided the question number one in the affirming, holding that when armed forces personnel is availing casual leave or annual leave, is to be treated on duty. While deciding the second question, the Honorable Apex Court in the para 20 of the judgment held as under in view the regulation 4 to 3 clauses, there has to be casual connection between the injury or death caused by the military service. The determination factor is a casual connection between the accident and the military duties. The injury be connected with military service, howsoever, howsoever remote it may be, the injury of or death must be connected with military service. The injury or death must be intervention of armed forces service and common to human being. When a person is going on a scooter to purchase household article, such activity even remotely has no causal connection with the military service. Regarding question number 3, the Honorable